and services provided by institutions of faith in the same fashion. This way, churches, synagogues, mosques, and other sacred places are clearly free to operate in accord with the faith of their members. That is the summary version of this bill, Mr. Speaker, and what it seeks to do. With all the controversy surrounding the concept of religious liberty and protection of personal conscience, it is my hope that many in my caucuses hope that this will be seen as a good faith effort to find common ground and to work together to reassure the faith community in light of our new legal environment. That said, I am open to questions or suggestions on how to improve or refine this legislation to mitigate any concerns that members of this committee or others may have, or to address any unintended consequences of the legislation. With that said, Mr. Chairman, I'll be happy to answer any questions.
All right, thank you, Chairman Tanner, for your presentation of the bill. I don't see anybody that might beat me. Are there any questions from any members of the committee? All right, Representative Bruce.
I'm trying to figure out what prevents, what mandates in current law that a pastor do anything that violates their religion.
There's not anything.
Okay. So they could, under current law, if I go to a church and say that I want you to perform a wedding, and you don't want to perform that wedding, under current law, they can say, well, you can't have your wedding in this church because you're not a Catholic, or you can't have your wedding in this church because you're not Baptist, or whatever it may be. If your belief is different than the church that you approach, then there's nothing that compels that pastor to perform any service outside of what that church stands for. Is that correct?
That is my belief, yes, sir, and my understanding of the law. I will tell you, after the Supreme Court decision, I received quite a few phone calls from ministers, pastors of various faiths in my community concerned about what this meant for them and their official capacity in that church. And they were concerned that Georgia did not have any specific protections. Now, we pass legislation every day designed to protect our constitutional rights and put that in state statute to protect our constitutional rights. And this legislation is an effort to reassure these individuals in this faith community that even though the legal environment may have changed as far as the definition of marriage, that they're still protected to exercise their faith in their church and on their church property, and the pastor able to exercise his faith in who he marries or doesn't marry in the manner that he sees fit in accordance with his faiths.
Okay, we're on the same page there.
Yes.
But the question that I'm trying to get an answer to is there's nothing that was in that Supreme Court decision that compels, to my knowledge, that compels a pastor to do anything that's in violation of their religious belief. From what I understood about that decision, it just says that you can't discriminate against people because of, artificial stuff. But it doesn't say anything to make me see that it compels a pastor to do something that violates their religious belief. And again, the argument that we had same time last year, with these religious freedom, so-called religious freedom bills, is that we are allowing ourselves to, as a state, to become involved in deciding things that should be decided, by that religious belief. And if it is that, the religious belief says that you're asking me to do something that's in conflict with, with this church, with this, religion, then there's nothing that compels them to do it. I mean, I had to go, when I got married, my wife was not Catholic, I'm Catholic, and it required us to get permission from the church to have our wedding in the Catholic Church. And we did it. We just went through the process through the church. And I'm just saying, it appears to be a slippery slope when we start legislating on behalf of religion and then at the same time say that we are a society that has a separation between church and state. It just seems like a conflict.
Representative Evans.
Thank you, Mr. Chairman. Thank you, Representative Tanner, for your presentation. And my question is a clarifying question, because you and I have talked about this, and I understand where you're coming from, and I think I understand where you're coming from, and I just want to clarify. You want to protect our pastors and our religious leaders of our churches, but you're not intending to limit any person's access to commercial services in any way.
There's nothing in this legislation that would limit someone's access to commercial services, no ma'am.
Okay, thank you.
Yes ma'am.
Chairman, please.
Thank you, Mr. Chairman. Representative Tanner, I believe, is it not true that Representative Bruce asked the incorrect question for this legislation? His question to you was, what in the law requires, I think, a pastor or his priest, for example, to perform a ceremony which they object to? The better question is, what in the law protects that priest from being sued if he chooses not to perform a ceremony that is against his religious beliefs? Is not that the correct question, and is that not the purpose of this legislation?
That's correct. There's nothing in Georgia statute that would protect that individual, and I can tell you in a personal situation, a deacon at a Baptist church in North Georgia, there's a concern among all the churches of their bylaws and making sure they're in order, of making sure from a legal perspective every I is dotted and T is crossed. And to the representative's point earlier, that's not something our churches should have to worry about. The churches should be free, and it should be very clear they're protected criminally and civilly from making decisions and then being sued for those decisions if they're making them in accordance with their faith. So yes, Representative.
Isn't it also true that this action, if your bill is passed, would protect a priest in the example that we were talking about earlier from a local government, not just a state government, but from a local government passing an ordinance that made some requirement upon them as far as what ceremonies they may choose or may choose not to perform? Isn't that correct?
That's correct. They would be protected under state law, and no local jurisdiction could override that. Yes, sir.
Thank you.
Yes, sir.
Chairman Willis. Oh, Representative Welch. Chairman Welch, go ahead.
Representative Fleming asked my question.
All right. Anybody else have any questions they would like to ask Representative Tanner concerning this? All right, Kevin, if you would just stick around, I'm sure that we're going to probably bring you back up.
Thank you, sir.
Can I see the sign-up sheet, please? I need to get it. All right, Mr. Jeff Graham, is that correct, Mr. Graham? If you want to come around, tell us who you are, please, and who you're with.
Thank you, sir. Chairman, members of the committee, my name is Jeff Graham. I am representing Georgia Equality. We are a statewide organization committed to the advancement of fairness, safety, and opportunity for gay, lesbian, bisexual, and transgender communities throughout the state of Georgia. With regards to House Bill 757, we do feel that the federal and state constitutional laws are sufficient to protect for religious beliefs and expression. However, there are no current laws on the state or federal level that protect the LGBT community against discrimination. I remain hopeful that as this conversation continues, we will recognize that Georgia is one of only 2 states without any form of statewide civil rights or non-discrimination legislation, and one of only 5 states that has no law addressing public accommodations. It is still in the best interest of all parties that we as a state address these gaps in our current laws so that all people and communities, including people of faith, feel covered and protected against discrimination in the law. I am very concerned about Section 3 of the current House bill. While we do want to make sure that places of worship are protected, the current language in our analysis is broader than that, and I do have concerns that it could be applied to religious organizations that have an affiliated nonprofit organization that are currently using state and federal tax dollars to provide essential community services. We need to ensure that these taxpayer funds are not used in any way to discriminate against any segment of our community. Furthermore, our research has indicated that in other states where there are similar laws to this one, the language has been limited to religious weddings only. I do hope that as the committee will look at this issue, you will choose to amend the language appropriately. Thank you.
Mr. Graham, might I ask you, you said it should be limited to just marriages only. It's just a statement that I have, a thought that I had. Also, as Representative Bruce has said, he is Catholic, and of course Catholic priest, as opposed to my religion of Baptist, grant and do, as well as do in the Jewish faith, rites and sacraments, not just marriages. Would you not agree that rites and sacraments, if you should also be a part of that other than just marriage itself?
Sir, I do believe that clergy have to have protections. Again, we do agree, or we feel that the federal and state constitution already allows for that. My choice of looking at weddings has to do with the previous comments that were made about how the Supreme Court decision last year does allow for all living couples to marry, including those of the same sex.
Well, if we were to add rites and sacraments along with marriage, would you be amenable to that in your opinion?
I would certainly be open to that. I would want to certainly look to see exactly how that language would be crafted before I could really agree to that. But certainly in concept, our concern is making sure that members of the public are not facing discrimination. We certainly have no problems with ensuring that members of the clergy, regardless of what faith that is, have protections as well.
Thank you very much. Any questions of Mr. Graham for any members of the committee? Mr. Graham, thank you very much.
Thank you, sir.
Mr. Anthony Kress, am I saying that correct? Christ. All right, sir. I apologize.
No worries.
If you'll state your name, please, and tell us who you're with.
All right, members of the committee, my name is Anthony Michael Kreis. I am a legal scholar at the University of Georgia School of Public and International Affairs, where I've dedicated much of the last 6 years studying issues that lie at the intersection of family law, civil rights, and religious liberty. I've worked on legislation similar to this throughout the country, and my scholarship has been published on this topic in top-tier law reviews. I'm here today in my individual capacity and don't represent any position of the university. While I do not object to the basic premise of the bill, it is worth reiterating as a threshold matter that the Supreme Court's decision in Obergefell recognizing same-sex marriage does not disturb the pre-existing First Amendment right of clergy to perform marriages consistent only with their faith. The absence of new legal dynamics, however, isn't a reason to necessarily oppose this bill. Indeed, there's nothing novel or new or unusual about codifying settled constitutional principles and protections in state statute. Between 2009 and 2013, every state that enacted same-sex marriage laws reaffirmed the principle of clerical autonomy with language quite similar to that proposed in Section 1 of this bill. And other states are following suit. Texas, for example, followed this model. Florida is currently considering legislation which largely also follows this national standard. Georgia's bill, however, does not conform as it currently proposed, mostly due with respect to the language in Section 3. While I believe the intentions behind it were almost certainly benign and an attempt to address issues in public accommodations law, the drafting process has resulted in a piece of legislation that reaches into fair housing principles. The third section is worded so broadly that it would actually open a broader exemption in Georgia's sole civil rights law and roll back protections afforded in the Georgia Fair Housing Act, which protects discrimination in housing on the basis of race, sex, color, familial status, national origin, disability, and religion. Currently, religious organizations have a limited pre-existing exemption to give preference to co-religionists, but otherwise must abide by principles of non-discrimination when engaged in commercial property transactions. In other words, the Pastor Protection Act would sanction groups to discriminate in housing in a manner they have never been allowed to since the passage of the federal and state fair housing laws. Indeed, as noted in the seminal case on this issue from the Third Circuit Court of Appeals in United States versus Columbus Country Club, the federal exemption was written primarily mindful of schools and other nonprofit institutions that have a direct affiliation with religious organizations engaging in non-commercial activity. More than housing, Section 3 would foreclose taxpayer-funded grants conditioned on equal public access, subsidizing properties that accept taxpayer-funded support but turn away law-abiding citizens from accessing those services associated with the property flies in the face of our civil rights tradition, notably Title VI of the Civil Rights Act of 1964, which bans various forms of exclusion from participation in programs receiving federal financial assistance. Other states have, in fact, enacted nuanced exemptions for religious organizations to not offer facilities, goods, services, and the like for the solemnization or celebration of a marriage inconsistent with the group's religious tenets without reaching into fair housing law. I hold out hope that this legislation can be amended to track what I instinctively believe was the author's likely intent and to follow the example led by other states. I'm happy to take your questions.
Anybody have any questions, Mr. Christ? Chairman Fleming.
Sure, yeah.
You teach at the law school? Or?
I teach mostly undergrads right now as I'm finishing my dissertation, which is a long slog, as I'm sure you all could only imagine. So,
what undergraduate classes do you teach?
They have me teaching Intro to U.S. Government, and my students will be here next week. So it's an easy class for me to teach, which I love doing. But they are all very excited to see you all next week. So if you see me around, be sure to say hello.
What housing laws are you citing that you think churches will violate by this being passed?
So the current Fair Housing Act in Georgia, the exemption mirrors that in federal law. And it basically says that as long as you're engaging in nonprofit activities, you can basically do as you see fit. But if you are engaging in commercial activities, which is very rare, I think, to be blunt, you do have to adhere to the fair housing laws. So this is because of the way it's worded in terms of, I believe it says lease or rent. It does reach into fair housing that other states do not. So a lot of other states, I think, like I said, what I think the Section 3's intention was to talk about public accommodations, right? You don't have to rent out your church pavilion for a marriage. And a lot of states have dealt with that issue with very nuanced, narrowly tailored language to deal with that issue without reaching into fair housing and the like. So I think that, just in terms of keeping Georgia's Fair Housing Act consistent with the federal Fair Housing Act, it might be prudent to look more towards the public accommodation side of things rather than broader language that can reach into fair housing.
Well, let my question then focus on the narrow area that I think you're speaking of as far as housing is concerned. I don't think it's a commonality for churches to engage in housing for people, but I assume it probably does happen somewhere. Let's say a church did run for lack of better terms, a halfway house. Just like they now choose who can use their facilities for other matters, wouldn't it be even more important that they be able to choose who would use their facilities in those situations?
I think sometimes, so where you might get into particularly thorny areas is if that church is taking state or federal funding to support that halfway house, the housing. And I think that the legislation should certainly address those particular situations.
So what about that is going to cause any problem under this law? I'm still trying to get to your point.
Well, as of right now, so if a church, for example, took federal or state funding, there might be local non-discrimination laws which would compel them, because they take taxpayer dollars to serve all who come, without giving preference to co-religionists and the like. I think the problem here is that because it is worded so broadly, you could run into situations where these institutions would get a free pass to take taxpayer dollars and then to deny services to the individuals who come and seek those services.
So you want to regulate who a church can and cannot can come into that so-called halfway house?
If you take state or federal funding, I think absolutely you should be able to serve all that come in. As taxpayers, we pay into the system and we subsidize services, and all taxpayers should be able to use that. Might be a different scenario, right? If you're operating a shelter and you are not taking taxpayer dollars and you're doing it in a total nonprofit capacity, that would be something that doesn't even reach within the scope of the Fair Housing Act. And there was some litigation out in the Ninth Circuit about that, right? That kind of activity is removed from legislation, but it's certainly when those situations arise where you get taxpayer dollars in particular involved that become more thorny.
So we basically narrowed your objection to this whole bill down to Section 3 in some form of a church that takes federal or state dollars for housing purposes.
Well, that, and I think it should be clear that if a not-religious organization engages in commercial transactions, like current federal and state law, which says that they have to adhere to non-discrimination principles, if they are engaging in commercial activity, I think that needs to be clear that position remains. I certainly think that the Section 3 can be amended to address some of these other concerns that might reach into housing, perhaps, but as it is, it's just slightly too broad. But I understand the intent completely, and I don't think the intent is necessarily, out of step with what's been happening in other states. It's just the language, I think, should reflect what other states have been doing.
Do you know of any churches that take federal or state funds to provide housing to people?
I have not done that type of research. I'm confident that there are, but
you just don't know of any today.
I can't. It's not. Most of my research is in the actual statutory language.
Thank you.
Yeah.
Representative Bruce.
Just for clarity, and there are quite a few churches that have housing, particularly for seniors.
Right.
I'm aware of several that do, and I guess I'm just trying to make sure that I understand what you're saying. Is the concern that if they're providing housing, just say for seniors, and the requirement for living in this senior facility is that you are a certain age or whatever, and that they're collecting federal funds or any kind of funds from government, any level of government that supports the existence of that housing, that this would be of concern if they were allowed to say that I could take federal funds or state funds or any other kind of funds from a government, but because you are not consistent with my religious belief, that you can't stay here.
So
is that the concern?
So I think here's perhaps a good example. If I'm a municipality and I have some funds and I'm going to provide funding for a particular service or program dealing with housing, but I say, as a condition of this, you must accept all, but the particular religious organization won't serve, won't house same-sex couples or won't recognize them as married. I think that might be a particular situation that might arise. Again, I get weary with dealing with fair housing issues when I really think what people are trying to do is talk about public accommodations. Every other state that's addressed this has basically said, property owned, controlled, managed by a religious organization doesn't have to facilitate or host or provide other goods and services for the solemnization or celebration of a marriage. They've stayed fairly clear away from anything called, broader language, renting, leasing, and the like that can deal with housing. I think that's an issue that requires additional consideration and thought.
Representative Kelly.
Good to see you, Anthony.
Good to see you
Good
too.
to have you over from Athens. How's the attitude yesterday on signing day over there?
Oh, pretty good to us.
Good.
Yeah.
Good. Just a couple questions. You just brought up I had one question. Now I got two.
Okay.
If a local municipality gives out a local grant, that's the example you were just talking about with Representative Bruce. Are you telling me that you think that this bill would keep a local government from being able to determine how they give grants purely from local money?
If I recall the language of Section 3, it says shall not. It's a command that it shall not compel. I don't have the language in front of me at the moment, but it shall not compel a religious organization to rent or lease inconsistent with their religious beliefs or something to that extent. So that very well may erode the ability for local municipalities to attach non-discrimination provisions to local grants in that particular situation.
And you talked about the Federal Housing Act and the state housing laws that we have. Based on everything I know of preemption, what we do here with this will still be preempted by the Federal Fair Housing Act, right?
Well, you would. My presumption would be you would be removing if a religious organization was engaging in commercial activity, and they would fall ordinarily under the state law. You would be removing a state avenue of remedy, and they would be. I mean, if you are covered by the federal law, then you're stuck with federal law. if you are dealing with a situation that perhaps deals with same-sex couples who are not covered by federal law, but might be covered under local law, you would be removing the remedy altogether.
Any other questions of the witness statement? Thank you very much, sir.
Thank you.
Those are the only two individuals that I have that have signed up. I've got a few more minutes, not a lot, but if somebody else would like to come up and have some statements to make to the committee. Mr. Chairman?
No, seeing that no one has come forward, I'd like to make a motion, if I may.
All right, let's hold me one second. Anybody? All right, thank you very much. It's now. Chairman Will? Yes.
Thank you, Mr. Chairman. I'm looking at page 2 under the section 2, which is the OCGA 10-1-573, paragraph B. It reads clearly to me down to the point where it says, no business, I'm going to paraphrase here, no business or industry shall be required to operate on either of the 2 rest days, which are Saturday or Sunday. And then there's a provision put in here about contractually obligated. Well, to me, if you're contractually obligated, then your responsibility is under your contract. If you breach the contract, you lose the business. Simple as that. I don't know why we need to have this phrase in here of exception. In fact, to me, it sort of clouds the issue, because what you're really talking about is if I'm a company and I've contracted to say that I will do picking up a trash or leaves or something, and I'm going to do it 7 days a week. I'm going to clean up a parking lot, and I walk in one day and say, "Wait a minute, I've had an epiphany, and I'm now based on my religion. I can't do it on either Saturday or Sunday, whatever their religion tells us, the day of rest." I say, "Well, your contract says you got to do it." I say, "Well, I'm not going to do it." And say, "Okay, that's a breach of contract." You lose your contract. Simple as that. Oh, well, it's not a matter of saying the law overrides the contract. And that's, to me, I think I'll just put a period after the Saturday or Sunday and strike the other portion of that sentence.
All right. Thank you very much.
That's my discussion on it.
Representative Evans.
I just have a comment on a separate issue. I think Representative Tanner maybe wanted to respond to Chairman Willard, but.
Well, I just wanted to give you the background on why that's in there, Mr. Chairman. There was a concern brought forward by local government, counties and cities on this issue because of, like an example you just gave, garbage collection or ambulance service provided to the city. And Legislative Council was of the same opinion that you were, but their attorneys were concerned that it could be interpreted differently, so they asked that it be made clear. So we worked with Legislative Council on this language to make it clear that it's not the intent of this legislative body through this legislation to say to a city or county, you cannot contract and require in that contract, which is mutually agreed upon, that you've got to be open 7 days a week and provide a certain service. It could be 24 hours a day, like in an ambulance situation. So that was put in there just to make it clear, Mr. Chairman, of the intent. Yes, sir.
Representative Evans.
Thank you, Mr. Chairman. Just a comment on Section 3 for the committee's consideration. I absolutely take the author at his word that his intent is to protect pastors against having to perform marriage ceremonies that are against his or her faith, and I have no reason to doubt that, and that it's not to exclude any person from services outside of that realm. But I am concerned right now with the way that Section 3 is worded that we may be doing just that. And so at the appropriate time, I have an amendment to offer for Section 3 to attempt to limit the language in the bill to its stated purpose. And it would also be consistent with similar legislation like this in other states that are very narrowly tailored to address concerns about marriage and a pastor's role in those ceremonies. And the amendment is also going to be offered out of the concern that, as was mentioned by a couple of the speakers, that a church doesn't just always act as a church. Sometimes churches are operating in a nonprofit realm that offers services, and they receive tax funds to offer those services. And I think our role as government is to be very careful that we are not sanctioning the use of tax dollars, or we're not giving organizations the permission to take tax dollars and to discriminate with those tax dollars. And I think that the housing situation that was offered is at play, but we also have to remember that a lot of churches operate nonprofit soup kitchens, drug treatment centers, and if it wasn't so late in the day and we hadn't had such a long day, I might be able to come up with some other examples. But I think we just have to be really careful here. And I also think that this keeps us out of the news. This keeps the message clear that we are simply trying to protect pastors, and we are absolutely in no way, shape, or form attempting to discriminate against any citizen of the state. And so at the appropriate time, Mr. Chairman, I have an amendment.
Thank you. Chairman Welch.
Yes, Mr. Chairman, I'd like to make a motion, recommendation to pass to the full committee. I do have an amendment that I would like to offer into Section 1, if you will. It's consistent with what the chair had asked before regarding rites and sacraments, and that as part of my motion, I would like to make that recommendation with the amendment to amend line.
Well, let's just see if we get a second on
I'll
this.
second.
All right, now we have a motion and a second to pass the bill. Now, concerning your amendment.
Yes, thank you, Mr. Chair. On line 16, after the word marriage, I'd like to insert a comma and then the words rite or sacrament.
All right, thank you. There's been a motion by Chairman Welch for the first amendment to this, that on line 16, after the word marriage, that a comma, rites or sacraments be added. There's been a motion and a second to that amendment. All in favor of the amendment would say aye.
Aye.
Opposed, same sign. That amendment carries.
Do you want to make your amendment?
I'll propose, if you move it forward to Section 2.
Yes, Mr. Chairman, go ahead.
Thank you. I'm going to propose that on line 31, after Sunday being in parentheses,
Strike the rest of that.
strike the semicolon and the rest of that sentence and enter a period.
Second.
There's a motion and a second concerning the second amendment, that starting on line 31, after the parentheses Sunday, strike the semicolon, put a period,
Yes,
and
sir.
strike the balance of line 31 and line 32. There's a motion and a second. All in favor? Certainly. I'm sorry, go ahead.
Sorry, to the author of the amendment, Chairman Willard. Is your amendment made? Do you believe that that you don't believe that the language as it would be written, if your amendment passes, would prevent a city from still contracting with an ambulance service, for example, and compelling them through the contract to work on Sundays?
Well, I don't know if you can compel them. It'd be a breach of a contract. So if you have a company that enters into a contract that says for 7 days a week, 24 hours a day, 7 days a week, 365 days a year, I'm going to provide a service to you. And they walk in one day and say, I'm not going to provide it on Sunday. Just use it as a date. That would be a breach of contract. And by a breach, they would say, okay, your contract's terminated. It may be a claim for damages, but beside that point, I think the breach brings about a default of the contract, and you now enter into a contract, and there's a number of companies out there that I can tell you, as ambulance companies, would love to pick up the business.
Probably so. You don't believe that the contracting party would be able to fall back and say and find any protection in this law in defense of their breach of contract?
No, because it reads the other way around. It says you can't be required to do it. It doesn't say that the company can require you to do it. So my point is, the individual says, I cannot be required to work on a day that is my day of rest. And I don't think there's anything that prohibits someone to raise as a question, if the right. And I represent a lot of Seventh-day Adventists, and they don't work on Saturdays. It's a very sacred day for them. I've had cases where they had companies try to compel them, and you have federal law that covers this, by the way, as far as federal law that covers the compelling someone to work on like a Saturday when that's their day of rest. In fact, there was a case that came out, I believe, in our state Supreme Court not too long ago dealing with that very issue on a Seventh-day Adventist working for a clothing store.
Mm-hmm. You've convinced me. I just worry because Smyrna contracts for the ambulance service, and I want to make sure I get to the hospital on Sundays.
Good point.
Anyways, any other discussion on the amendment offered by Chairman Willard? All in favor of his amendment will say aye. Aye. All opposed, same sign. Amendment carries. Any other amendments from any members of the committee? I apologize. I can't see it. I'm always looking the other way. I apologize, Ms. Stacy. Go ahead.
That's all right. Thank you, Mr. Chairman. I think an amendment's being passed your way right now, the one I alluded to, and it deals with Section 3, and it would amend lines 42 to 44. Wait till I think everyone has it. So that the language as amended would read, no religious organization shall be required to rent, lease, or otherwise grant permission for property, inserting the words property that it uses for religious and non-commercial purposes to be used by another person, and then striking the remainder of the language and adding for the solemnization of a marriage that violates its sincerely held religious belief. And not to repeat everything I said during the comment section, but the purpose of the amendment, I don't believe changes the stated purpose of the bill, but does protect us and prevents us from any unintended consequences of a religious organization being able to use taxpayer funds for discriminatory purposes.
Thank you.
And I move that as an amendment.
Chairman Flynn.
Thank you, Mr. Chairman. For Representative Evans, so you would intend to force a church that has a fellowship hall, for example, to allow something to go in there other than a marriage, even if they object to it?
No, not at all. But if a church accepts taxpayer dollars and runs separately from the church a soup kitchen, a domestic violence shelter, a lot of the other things I mentioned earlier, drug treatment centers, soup kitchens, homeless shelters, senior housing, domestic violence clinics, that because they've decided to take taxpayer dollars, they have agreed to accept the public, and they cannot accept.
Where
they
in your
can't
amendment
decide.
is this limited to a church that takes taxpayer dollars?
Well, where we're talking about in the second line of the amendment, that property that it's using for non-commercial, the property that it uses for religious and non-commercial purposes is protected. So what you're concerned about is absolutely still protected. There's no church that's going to be required to perform a marriage ceremony in the fellowship hall.
I'm not talking about performing a marriage. I'm talking about using the fellowship hall for anything. My church rents their fellowship hall to the local high school boosters club to have their banquet in there. They rent it to the Boy Scouts and the YMCA to do things in there because it has a gymnasium in it. You're saying you're limited it only to marriage by this amendment, and you say nothing about also a limitation to public taxes being used, which is a stated reason why you want this in here, but it's not limited to that.
Well, I'm open to a friendly amendment that would add that, but it's further limited because you're not going to. No other person can be required. The church is not going to be required to allow a person to use any property whatsoever for the solemnization of a marriage that violates its sincerely held religious belief. So, by the language of the amendment, it's not being limited. The church is not limited in stopping the use of its property for anything else.
But you would agree with me that an awful lot of important stuff goes on at churches other than marriages.
Absolutely. I'm not disputing that.
Thank you.
All right. We now have there's a motion made by Representative Evans, and y'all all have a copy of her amendment that she's offering.
Just one.
Chairman. Well,
I think that there is some merit in what the representative is proposing. I'm not sure that the language gets us quite there. Would the representative be willing to to allow us to move the bill forward and discuss this in full committee.
I would be willing to hold the amendment for now with a good faith gentle lady and gentleman's agreement that we can work on some language that would be agreeable to the whole committee.
I would like to extend that olive branch of good faith and work with you on that.
I will take it and I'll withdraw the
All right, Mr. Evans' amendment, motion for amendment has been withdrawn. The bill is now in the breast of the committee with the two amendments that have been offered. All in favor of passing the bill as amended will say aye. Aye. All opposed, same sign. Bill moves to full committee.
Thank you.
Thank you all very much.